The rule of law is fundamental to the development of every human society, and in the absence of same, there will be chaos and anarchy. The workings of the court. The court exists to resolve disputes after a proper consideration of the case of litigants. In the courtroom, the litigants are masters of the facts, their lawyers are masters of the law, and the court is the interpreter of the law. The court applies the law to the fact, considering the details of the evidence the parties have adduced during trial, and make pronouncement, which is referred to as a court verdict or judgment. The quality of evidence adduced by a litigant determines whether the claim has been proved or not. The production of evidence, therefore, is solely the responsibility of the litigant. The rule of evidence is that he who asserts must prove. The proof on a civil case is on the balance of probability, while in a criminal case, it is beyond reasonable doubt. It is not the way of the court to go look for evidence for litigant, and the court cannot make a pronouncement outside the evidence adduced by parties. So where a party makes an allegation or asserts a claim, in his pleadings, the onus is on him to prove same with evidence. A claim that is not backed up by evidence or proof is deemed abandoned. In Elias versus Omobari, 1982, 5 Supreme Court, 13 at page 22, where Udo Udoma JSC, as it then was, opined thus, and I quote, "If there was ever any case completely starved of evidence, this is certainly one. This case clearly cries to high heavens in vain to be fed with relevant and admissible evidence. The appellant woefully failed to realize that the judges do not act like oracles of Ife, which often engage in crystal grazing, therefore would proclaim a new Oba in succession to a diseased Oba. Judges cannot perform miracles in the handling of civil cases, at least to all manufactured evidence for the purpose of assisting the plaintiff to win a case." In the just concluded case of Peter Obi, Atiku, INEC, and President Bola Tinubu at the Presidential Election Tribunal, the Labour Party, though courageous and law-abiding, went to the tribunal to contest the victory of Bola Tinubu of the APC. In the tribunal's judgment, it was said largely that the LP candidate in the election could not prove irregularities and or substantial non-compliance with the Electoral Act. The allegations were generic and far-reaching, but the proof brought forth by the legal team were either too weak or non-existent, so their claims failed. There have been public outcry in some quarters that the court was compromised to cede victory to Bola Tinubu. From the foregoing, I feel the public largely isn't conversant with the workings of the court, and so I say, I urge you, brethren, to understand that litigation is about evidence and proof, and in the absence of these, the courts cannot act otherwise. The courts have a duty to the society to do justice at all times, and the court should be trusted to do so. It is not right when members of the society go around issuing threats against judges and the judicial system. The court will not change its modus operandi, which is founded in law to please the public. The obligation of the court is to ensure that justice is seen as manifestly done. If the court perverts justice, it can be called out, but not threatened and intimidated. Nevertheless, litigants have a right under the law to explore their options of appeal in the interest of justice. I shall go, Rabbi.